Howdy. How do? What is up, people? Good evening, Aurora. Aurora. What up, Punky? Hi, Punky. I'm not monetizing. What up? Brett is in the house, too. Hey, Leanne. Glad you can make it. Pow pow. Pow power. What up, witchy woman? Hi, Mary. Trouble. Always trouble. It's good when trouble's here. Christina, hey, glad you could make it. Hey, Tam, glad you're here. Nadia, what up? Chris Baker, too. All right. Sorry I was a little late. I had to make a stop. I was supposed to make a stop around 4:30. Then I fell asleep for like 15 or 20 minutes. Can you guys hear that? That's loud, right? I was supposed to run an errand and then fell asleep for about 15 or 20 minutes, and I woke up and I was watching House of Cards on Netflix. House of Cards with Kevin Spacey. Great series. If you haven't seen that, it's like Washington D.C. meets The Sopranos. It's really good. You should watch it. It gives you, I think, real insight. I mean, it's a series. It's a drama, but I think you get to see what really goes on behind the scenes and how decisions are made and things that happen, mysterious things. Um, so I got hooked on that. And next thing you know, I'm watching. Next thing you know, it's almost 7 o'clock. Then it's almost 8 o'clock. And it's like I have to run out and get some water. I fill up my 3-gallon jugs of water, and then Tammy called me up. He said, "Hey, I got some stuff for you. Come pick it up." So I've got, yes, thank you so much, courtesy of Tammy and Tammy's Tasty Cuisine. This one is peanut butter chocolate chip cookies and chocolate chip cookies and a crap ton of other stuff. Cinnamon rolls and pineapple cakes and matcha bread. I'm probably gonna stay awake most of the night just so I can taste all this stuff. But if you want to order some of this, remember this is sugar free. It's made with your health in mind. You can talk to Tammy on her page. That's her logo right there. You can find her on Facebook. She does ship throughout the country, and peanut butter chocolate chip cookies. Mm. Mm. Yeah. I taste a little bit of coconut. Or is that the chocolate? So good. So, if you don't mind, I'll be snacking on that while we're watching some of this stuff. Goodbye diet. No, I'm planning on doing the grilled cheese thing sometime this week. Some crazy people are telling me to put mayonnaise in instead of butter. I'm like, I'll try it. I don't mind mayonnaise. I'll try it. Yeah, Punky. Okay. What is this? What are you moronically? What are you trying to say? Stop what? What are you talking about? The peanut butter chocolate chip is guiltless. Oh man, it's so good. What up, Christine Michelle Boras? Is that right? Boras or Buras? I think it's Boras. Search Patrol, what up? So, the thing I wanted to ask last night, I saw a TikTok video, or was it a reel? I can't remember. One of those. And they were talking about how Girl Scout cookies, and in particular the Thin Mints, the Girl Scout Thin Mint cookies were the exact same cookies that are found at the dollar store. Well, I forget what they call them at the dollar store. They call them. He showed me. I forgot. It was something to the effect of thin fudge mint. I think it was fudge mint. He's like, "Are these the same?" And they're made by the same freaking factory, the same address, the same company. The manufacturer, the address on both boxes is identical. So the difference is one costs $6 and one costs $1.25, whatever, a dollar. And if that's true, that's like amazing. That's remarkable. And I will say this: the Girl Scouts do it because it's a fundraiser. That's how they raise money for their organization, for the activities that they do, for all the things that the Girl Scouts do. That's why they're $6 a box, and that's why you should continue to buy and support the Girl Scout cookies and buy Girl Scout cookies. So, just because this video is going around of the difference or similarity, now you know where you can get them when it's not Girl Scout cookie season. But when it is Girl Scout cookie season, please support your Girl Scouts. It is a good cause, and we don't want to take anything away from there. So when it's off season, you know where to get them. What up, John Allen? You lived in the Valley back in 1914? 1914? What up, OG? Hey, Yanira. Sarah, what up? So, somebody sent me this, and I thought it's a year old. All right, the Cubs are about to win this game. Oh, no. Sorry, I'm watching the Cubs game over here. Bases loaded, no outs, bottom of the ninth. It's tied 2-2 against San Diego. They're playing at Wrigley. So that's why I left my W flag, in anticipation of a victory tonight. And as usual, they wait till the ninth inning to, wake up the bats and possibly win this thing. Right, Christina? Oh, you tried it. The Tillamook is so good. I think it's really good, and they make ice cream too. And the ice cream is, oh man. I knew the ice cream was different because, that's always the last thing I get at the grocery store. The last thing is ice cream, and then hurry up and get to the car because it's like 1,000 degrees over here, and then turn on the AC, and then get home and throw it in the freezer. But by the time I'm getting home, it's already really soft and it's different. It's made differently than regular stuff like the Briars, which I was heartbroken to find out it's not. They can't call it ice cream. Here we go. Okay, fly ball to left field. Ah, thrown out at the plate. Dansby's not that quick. Anyway, it's good. It's really good. You should. Everybody else give Tillamook a try. They make good stuff. And yes, they make ice cream, and then they make something else too. I just saw it. I was like, what? They make what? Hey, it's possible. Moronically could be, 114, 100 years old. 100 and whatever years old. No, that's cool. Moronically, that was actually pretty funny, so no worries there. Yep, that's lost again. Yeah, sorry to hear that. Tillamook. I haven't even looked it up. Is Tillamook a place? I guess. Where? Oh, Oregon. Okay. Whatever the case, Tillamook is good stuff. I suggest you try it. Partial to the Cubs win. It was almost a grand slam. The guy had to jump up at the wall at the ivy, and he couldn't come up with it. That was a hard catch, but anyway, Cubs win, so I'm a happy camper. I already forgot what I was saying. Yeah, it is good stuff. All right, so I found somebody sent, and I didn't find it. Somebody sent me a link, and they were asking, "Is this from Vanessa's stuff?" I'm like, "Oh yeah, it certainly is." And I just thought it'd be an interesting read. I read it once, and then I sent it to a few people, and they said, "Man, it's actually a good read. Gives a lot of insight." So let me show you what that is. Yeah, Mary's really good. Alrighty, where is this thing? Okay, as you can see, this is documentation from the state of Texas versus Vanessa Tijerina. This is the appeal from 197th District Court of Cameron County. And this was their decision. So this has to do with the food stamp fraud case. This is public information. I didn't have to bribe anybody in order to get this, or it's not illegal. This is on a public website. And this is from July 31st, 2025. So almost exactly a year ago. This has to do with her food stamp fraud case, which after so many years, at this point, it was probably just over 8 years, that her attorney filed for a motion to dismiss, or actually to dismiss. Legally, I don't know the difference between the two, if there is a difference. Um, a motion to quash challenges how a lawsuit or document like a subpoena was issued or served. A motion to quash challenges how a lawsuit or document was served. Okay, a motion to dismiss attacks the legal merit of the lawsuit itself. So quash means this is no good, it's full of errors, they didn't do this right, they didn't do that right, please quash this. a motion to dismiss. It's like, yeah, you know what? This is frivolous. This is ridiculous. Like, yeah, let's just dismiss this. So her attorney filed a motion to quash, and so it was sent to appeals court. And there they mulled it over, and then this was the result of that. It's quite a few pages. I think it's 12 pages. And you should, that's actually interesting read if you've never read one of these things before. But they explain everything that was going on, and then how they got to they're arguing their decision back and forth with annotations and a transcript of what was said in court. Just real quick, you know what? If you can't, it's too small, right? Hold on. Whoa, hang on. That was freaking weird. Hang on. I'm gonna try to. Okay, that's that. Now, hopefully this is better. This is better, right? Yeah, quash. Like quash. It's like, if they're going to say quash, why not just say squash it? Squash. That's what I would have said in court. Hey, Marcy, what up? Yankees fan? Yeah, I know. It's okay. I forgive you. All right. Oh, one more thing before I start reading. I'm not going to read the entire thing, but I'm going to hit certain spots. Is the music too loud, or can you guys hear me okay, even with this background music going on? Please let me know, because I don't want it to be too loud. Yes, Diet Coke with lemon right here. Thank you. Okay. All right, sounds good. Where should I start? Let's see. By one issue or with four sub-issues, appellant, the state of Texas, challenges the trial's court order quashing the indictment that charged appellee Vanessa Tijerina with one count of aggregate theft. Then it says see Penal Code annotation subchapter 31.09. We reverse and remand. And then it tells you August 27, 2020, the state re-indicted Tijerina as follows. And then it goes on to tell you that began on or about March 16th, and that's where this comes into play. Okay, well, let me just read it. And continued until on or about August 31st, 2016. So they're saying from around March 16, 2012 to August 31st, 2016. And before the presentment of this indictment in the county of Willacy and state of Texas, Tijerina did then and there, pursuant to one scheme or continuing course of conduct, unlawfully appropriate by acquiring or otherwise exercising control over property, to wit, which was Supplemental Nutrition Assistance Program, that's SNAP, and Medicaid benefits. The aggregate value of the property obtained was more than $20,000, $20,000 or more, but less than $100,000. I know it's a huge range, and there's different classifications of the crime depending on how much. If it was like, $100, then they're like, yeah, that's small claims shit, didn't they? And then if it's big money like this, then you're talking different classification. From Texas Health and Human Services Commission, the owner thereof, without the effective consent of the owner, namely by deception and with intent to deprive the owner of the property. The owner being the state of Texas. So in this case, when they say the owner, they're talking about the Texas Department of Health and Human Services. Pursuant to Article 27.08 of the Texas Code of Criminal Procedure, Tijerina filed a pre-trial motion to quash and exception to the substance of the indictment, arguing that prosecution for the charged offense was barred by a lapse of time. More specifically, she asserted that the statute of limitations for a theft offense is 5 years from the date of offense, and as such, any alleged theft prior to August 28, 2015 was time barred since she was indicted August 27, 2020. So basically they're saying, well, the statute of limitations, this is old already. You shouldn't have re-indicted her. She also argued that the state was attempting to avoid the 5-year statute of limitations by improperly using, and they refer to Article 31.09. Finally, she contended that there was not a scheme or continuing course of conduct that would justify suspension of the 5-year limitation period. And her application for need-based medical and nutritional benefits was neither a scheme or ongoing illegal course of conduct in 2012, 2013, 2014, and 2015. Any alleged theft during those years is considered a separate violation and not an ongoing scheme to commit theft. I don't know how that would be. But it says, therefore, Article 12.01, and then there's some little notes right there. Fourth, the statute of limitations for various felony offenses would bar the state from prosecution for any theft prior to August 28, 2015. Additionally, each alleged theft must be identified by date. So what they're saying is that the prosecution, the state, said, okay, there's a range here. She defrauded the house, we'll call it the house, Texas, between August and, whatever the other date was. But they're saying, well, that's just a range. What they continue to say here, that there's nothing specific. That's what they're saying. Okay, I'm right here. I'm just going to read out some of this. I'm not going to read the whole 12 pages. I don't want to put anybody to sleep either. Tijerina prayed that the trial court quash the indictment due to its defects of substance. The state filed a response in disagreement. On the day of trial, March 18, 2024, the state announced not ready and requested a continuance citing staffing reasons, and Tijerina announced ready. So the state said, we're not ready. And then the defense said, we're ready, subject to being heard on her motion. After denying the continuance, the trial took up Tijerina's motion in the following colloquy. I don't think I've ever seen that. I've heard the word, but I've never seen it spelled. So this was a back and forth between the court and the prosecution. And the court said, assuming as a judge, and the concern I've got is during that period of time, it took about 1.5 years for y'all to re-indict this defendant. And the prosecution said, yes, Your Honor. And then he continued on the same charges. And I do not understand that I know that the period of time that it took to indict her, or that period of time did not, or I guess the statute of limitations ran during that time. It did not run, did not toll, obviously, when the charges were filed. And I do understand that argument, but I do not understand. I guess I'm trying to figure out the what your argument was, Tijerina, as far as why this case should be dismissed. Are you trying to get the whole case dismissed? Or is this just some type of charges, or just some of the charges, or get it reduced, or and then the defense? Well, I think the argument could be both, Your Honor. I mean, what we have here is an indictment that is insufficient in giving notice to the defendant. We have an indictment that alleges a theft between 2012 and 2016, and the judge said 16, yeah. And the statute of limitations, if the case was filed in 2020, which is the date that we have, it would only relate back to 2015. So we have 12, 13, 14, and part of 15 that they're trying to aggregate into a theft case. But there's no notice in the indictment that any of any thefts. There's no dates in that indictment. There's no alleged theft. There's no victim in the indictment. I don't see how there's not a victim. Obviously, the state is a victim. There's no victim in that indictment other than one government agency. There it is. They don't even allege in that indictment who, where, who, when the thefts that they're aggregating. And that's where I go when I mentioned earlier, they want specific dates of when things happen. But you apply for these services one time, and unless anything changes on a monthly basis, hang on. Yeah, we don't need to hear that one. I apologize. Here, let me just throw this on here. So you apply for benefits, and then, if I'm not mistaken, every month, or depending on the benefit, sometimes every year, you have to update the court. Are you working? Did you earn money? Were you given money or whatever? It's stuff like that. I believe if you receive money, I believe you're supposed to report it like immediately, not wait a year. So that's why I don't see how they could give a specific date. Like this is when she applied. So the allegation is that she lied on the application. She said that she lived alone, just with her and the kids. But actually, she was living with Dude, and Dude was working, I believe. And so there were more, it was just a false application. Yeah, Witchy, exactly. I believe that too. I believe that too. So then they go on to say, when it says they were, let's see, the indictment in itself, I would argue, is insufficient and should be dismissed as a whole. But it's definitely a theft case that's outside of the statute of limitations. So that right there, I mean, that sentence, the indictment itself, I would argue, is insufficient and should be dismissed as a whole. But it's definitely a theft case that's outside of the statute of limitations. I mean, how more clear, and that's the defense talking. Cookies are so soft. I love them. And then he says, how can I defend my client from a theft case between 2012 and 2016 when they don't even allege a date? They don't allege a victim. They don't allege a crime. To wit, what? To wit, read. Read that indictment and tell me to wit what? It's not even in there, Judge. How do you get ready for a theft case when they don't even allege it? And it's outside the statute of limitations. So I would argue that the indictment is insufficient and should be dismissed on its face. And I can see where they're coming from. It sounds like the district attorney, the state, whatever you want to call them, the prosecution wasn't specific enough in the indictment. That's what that sounds like to me. Towards the conclusion of the hearing, the trial court decided to quash the indictment and clarified its decision as follows. So the judge says, but at this point in time, as far as the motion to quash is concerned, I'm going to quash the indictment. All right? The state says, and, Your Honor, just for the record, the court is not making any findings on whether or not the statute of limitations issue. And the judge said, no, I'm not making a finding on that. The indictment, in my opinion, is defective as far as I'm concerned. And that's what I'm doing. So I am dismissing the case at this point. And then a written order was later entered by the trial court granting the motion to quash that contained no findings. So a criminal defense, standard of review. And these are some of the things that perhaps should have been in there originally. A criminal defendant has the constitutional right to a fair notice of the specified offense against him. Like I would say in detail, I imagine that's what they meant. Like spell it out. See U.S. Constitution. Okay, so they want you to look at the constitutional amendment. They want the defendant to look at the the prosecution. The constitutional amendment, 6 Texas Constitution. A bunch of stuff to look at. There's a lot of these popped in there, and I would imagine they have to go to each one. What this is, they're citing cases to make their case hold water. We're saying this, and you can look at this precedent, this case over here that happened, 1978. And for that reason, that's why we're standing behind this. And the Texas and United States Constitution to grant a criminal defendant the right to fair notice of the specific charge offense. A defendant does have a constitutional right to sufficient notice as to enable him to prepare defense. Consequently, instruments must be specific enough to inform the accused of the nature of the accusation against him so that he may prepare. So, as some of us have said a lot, it sounds like the DA really messed this up. Like, something so simple. So I can see how it got quashed.
Roy Marukin, Roy. All day long, Roy.
That's funny. Let me start this all over again from I know what to do. Let me do this. All right. It's a lot. It's a lot to read, and if I could redact this and remove all these, reference to notes, see this or see chapter this or see constitutional amendment that. This would probably be, just a few pages long. Okay, the argument. Motion to quash. Broadly, the state asserts that the trial court had no authority to quash or dismiss. So this is what the prosecution is saying. The state asserts that the trial court had no authority to quash or dismiss the indictment under any of the three grounds alleged in Tijerina's motion, because Tijerina concedes the state's first two sub-issues, which I don't have those. It says, see Texas, blah, blah, blah. Accordingly, we consider the state's third sub-issue. The state relies on a series of cases from the Texas Court of Criminal Appeals for the argument that Tijerina failed to trigger the more demanding notice requirement that the trial court appears to have imposed on the state, even though there is no indication in the record as to how many transactions form the basis for the aggregate theft presently alleged. So this goes back to that, does what she did constitute a crime? Like the minute, like is just a filing a false application, is that enough? Or does she have to, file a false application and then make a purchase with that false information that she was granted, the funds that she was granted? And once she actually makes a purchase or uses the benefits, is then that considered now it's a crime? Or does it have to reach a certain dollar amount used from the benefit that, okay, now it's, it passed 5 grand, so now it's a crime? Tijerina responds that her trial counsel correctly argued at the March 18th hearing that the indictment was defective for want of specific notice. Upon further review of 4 cases relied on by the state, we do not agree with this argument as the state frames it. To elaborate, we do not agree that simply referencing a record allegedly showing numerous transactions triggers a determination that additional notice must be provided to the defense than that already provided in a changing instrument. Instead, these cases will show that the determination of whether additional notice is needed is triggered upon the filing of a pleading or motion raising a lack of adequate notice, challenging or a hindrance to an accused to prepare a defense. Let's see. So this other case, the case of Swabado, explaining that appellant was entitled to know upon filing her motion to quash which monthly staffing report the state was relying on to prosecute her. Again, be more specific. They were not specific enough. And the state was obligated upon demand by motion to quash to inform appellant of the persons whose names she falsely entered on the reports and the dates on which she falsely reported them as working in order to identify the alleged criminal acts. So let me just skip through a lot of stuff. I can put the link out there if you guys want to read this on your own. And then after all that, on the last page, based on the above, we do not engage in a two-step analysis to determine whether the indictment at issue provided adequate notice. See Zuniga 512 of Southwest 3D. Additionally, there has been no trial from which to show harm. The situation before us is not subject to a harm analysis. See Moff, another case. Because the indictment was quashed and the state appealed the decision of the trial court rather than refile the indictment, there has been no trial. Since there was no trial from which to show harm, the situation before us is not subject to a harm analysis. Accordingly, the trial court erred The trial court erred in granting Tijerina's motion to quash, and we sustain the state's sole issue on appeal. Conclusion: we reverse the trial's court ordering granting the motion to quash and remand for further proceedings consistent with this option. And there is a lot of stuff in between there, and I can I will post. I don't think I think that the link is too long, and I don't know if it'll let me pop it in the comments here. It might be too long. Hang on, let me try. Can somebody I put it in the comments. Can somebody let me know if that works? Somebody click on that comment that I put up and let me know if it opens up. Sometimes if a link is too long in these comments, it will not allow you to pop it on there. Yeah, Regina, I'm going to get to that in 1 second. Hold on. Then, well, it was reversed, but she had to be reindicted. So she was reindicted. It doesn't work. Okay. Then I will post that to my page if you want. I'll do it right now so we can, so you guys can, if somebody wants to go look at it, you can do so. Give me a second here. Again, this is all public information. I'm not being shady or anything like that. All right, I just posted to my page. If you want to go on Facebook, Manny's Hard Truth, it is there. In fact, I'll pin it to the top. There it is. It's pinned to the top as featured, right? I guess it worked for some people, whatever. Again, I posted the link to that document on my page. Go to facebook.com/Manny's Hard Truth, and it is there. So feel free to look through that. I'll probably give it another read later. And sometimes it'll be easier to read if you have a marker, you can redact or black out every time they reference to something, because there's a lot of that, which obviously a lot of us are not going to go look up, because you'll be there for 4 days before you get done with that document. So yeah, so that was my that was the reason for yeah. Yes, that was the reason for that. Oh, how come this is not there? Let's see. Someone sent me this. This is a fan favorite. Who wore it better? Remember the who wore it better? I swear I'm not making this up. This is exactly. Top left is what she wore. Top right, well, you know what that is from. And it almost matches to a T. That's a favorite photograph of many people, including hers. She absolutely loves it. I shit you not.
You can't handle the truth.
Preach. Yep. So there's a whole other bunch of documents, but I'm not going to do those today because there's a lot of stuff there, and that's we're going to do that tomorrow. Mañana we'll do a Taco Tuesday document reading party. Hey Jen, 3 years. Oh, you're awesome. Did you even know? I'm just asking. So, so she was reindicted, and then, of course, she had to get a new attorney, and they finally scheduled something. And I was like, oh man, they're gonna do this like in 2027 or something. And this was in March or February, something like that. But no, they set the date for March, and finally that date came, and lo and behold, it looks like they made a deal, and it's in the docket at Cameron County, public docket, that says the deal has been made. Parties have agreed. The defendant will pay restitution. It doesn't say how much in there, but it says that the defendant will pay restitution. Hang on a second. And that's why the other day we're talking about, and I posted yesterday, did you guys see the video clip of Marsha Clark? That's from one of her books. And she talks about, she talks about the difference between no contest and not guilty, or no contest and guilty. And essentially, why would you plead no contest? Because you're still accepting the punishment. It's just for show. Instead of guilty, it shows as no contest. Which basically means I give up, but I'm not going to say I'm guilty, even though you're guilty. And if you need that, let me see if I can add that here. Give me a second. Here, you know what? I got it here. Yeah, I'll pop it up here. This is in download, so let me do this. Oh man, I gotta convert this to really. Let me try this. I gotta convert it. Give me a second, guys. Oh no, hang on. All right, give me just a minute. I gotta convert this little tiny file. There we go. All right, now it should work.
Someone passed around a copy of the LA Times. It carried a report that Simpson had roughed up his wife on New Year's Eve of 1989 and that he'd pled no contest. This is the standard plea a defendant cops to when he's caught red-handed and wants to save face.
Did you guys get that? I'll play it one more time.
Someone passed around a copy of the LA Times. It carried a report that Simpson had roughed up his wife on New Year's Eve of 1989 and that he'd pled no contest. This is the standard plea a defendant cops to when he's caught red-handed and wants to save face.
So that's what pleading no contest is. It's definitely not saying I'm not guilty, because otherwise you would have pled not guilty and went to trial because you say you're not guilty. And remember, do you remember her saying that? I'll never go to trial. I mean, I'll never plead. I will never plead. I want a jury trial. I will never plead. I want a jury trial. So there was a plea deal because I'm sure her attorney told her, okay, a jury may find you guilty, and with that guilt comes X jail time or X probation plus restitution. All these things can happen. Any combination of all that can happen. So she pled, like people would do. It's just comical in this case because she swore up and down forever that she will never plead. She wants a jury trial, that nobody will find her guilty of this. I know you guys have heard it. I remember. I remember her saying that. Yes, this is a okay. Okay. The question is, this is a felony. Yes. What does that mean for her nursing license? Okay. So when they make a deal, you can negotiate all these things, and I will bet you, I will bet money if I had it. I would bet money that this will not affect her license. I'm guessing this is a deal. This is according to the Cameron County docket. We have reached a deal. The defendant will pay restitution. I got the thing here somewhere. I can. I'm gonna find it. I'll find it. I know I have it. It might take me a little bit to find it, but I know I have it. Man, when was that? This was March. Hold on. I think I'm getting warmer. Okay, I found it. This is what the docket says. Dated March 23rd of this year. Attorney Stephen Todd was present on behalf of the state. Attorney Louis Cirola was present on behalf of the defendant. Parties reach an agreement. Defendant is ordered to pay restitution as set out on the record. Case set for status hearing on 9/14. So an educated guess says September 14th is when she needs to pay that, have that restitution fully paid on or before that date. That's what that tells me. Unless anyone thinks different, that is an educated guess. What they are not making public yet, or if it is public, it's not anywhere that's easy to find at the moment, is how much is restitution. Okay, okay, I got some more info. Thank you for that. Okay, so the agreement, yes, I'm still here. The agreement could be something like, okay, let's downgrade this from a felony to just a misdemeanor. She will pay, as long as she pays restitution, this will get reduced to a misdemeanor and there will be no jail time. Or something like that. Something like that. Or, you know, well, we don't want this to be a felony because she needs to keep working. So one theory is if it's a felony, typically according to the Texas Board of Nursing and the state of Texas, that will jeopardize her license. But if it's not a felony, her license should be safe. That's the thought. Okay, so before I get to that, they could have made some kind of deal in any of that. Probation, how much is restitution? You know, restitution, the amount that was, we'll call it stolen via theft, is said to be over $70,000, over 74,000 to be exact. Not quite 75, but it was over 74,000 if I remember correctly. So she would have to pay restitution of whatever number they agree with. I got a feeling the court reduced that number. Again, by educated guess. And, you know, watching these things on TV and on the news, actual trials, how they reduce amounts that are owed. I've seen some ridiculous things happen. So that could have happened. Don't know the exact amount. So keep that in mind. Let me show you something else. Let me see, do I need to... Okay, that's good. All right, let's look at this one now. Somebody looked it up and sent me this. According to the internet and Google, yes, you can lose your nursing license for committing SNAP fraud. Under the Texas Board of Nursing, BON, rules, any criminal conviction, deferred adjudication, or court finding involving fraud, theft, or deception is grounds for disciplinary action, including the suspension or revocation of your license. Because SNAP, food stamps, fraud is considered a crime involving deceit or moral turpitude, it falls directly under the bond's jurisdiction regarding good professional character and criminal conduct. There you go. If you want to screenshot it, go ahead and do so real quick. I'm going to take it off. And so whether it's according to this, It doesn't matter because it doesn't refer to, well, if it's a felony or, if, as long as it's not a felony, it doesn't say anything about whether it's a felony or not. Bond, Texas Board of Nursing has the jurisdiction regarding good professional character, which means they could see what happened and they could go, yeah, we don't want to deal with you. Let's suspend or cancel your license or whatever. That can happen. And thank you for that, for someone who sent me that. I don't want to say who it is in case they want to remain anonymous, but thank you. I know they have a morality clause, yet they've been allowing all this freaking behavior to go on for years, and that's why I don't have too much faith with whatever Texas Board of Nursing is going to do. And let's see, John L. and Big AK Raymond has a status hearing, theft of property. So there's supposedly a status hearing, yes, for, we believe it's the theft of sunglasses. So how is this? So part of the deal is if she gets restitution, if she pays the restitution, still a penalty could be probation, which is something that is applied for, is requested. But if you have charges, other court cases, and those, if you're found guilty of those, how is that going to affect her, if there's a application for probation in this case? I assume there is, but I think a lot of this depends on what she comes up with on September 14th. Somebody's asking, is there any court for the dollar store fiasco? No, because there was no crime committed there, other than looking like a jackass. Tampering with a witness, that's a different one. That's a different one altogether. Sundance. Did the witness tampering felony arrest by the Texas Rangers jeopardize her probation? If probation is part of what's requested in this deal, personally, I believe it does jeopardize. Kathy, didn't you get a DUI last Friday? Not that I know of. Not that I know of, unless... No, that would have been all over the place. I don't believe so, Witchy. I'm sorry, Kathy. Yeah, that's what I'm looking for. There may be something coming up in August. I have to look at that again. And I'll let you guys know. Sorry, I want to go backwards on these comments. So that most recent arrest was a warrant for I'm gonna look up, I forgot what the term is. Unless you remember, John, do you remember what that's called? I forgot the word. It's a term. think I remember. No, that's not it. Hey, do you recall what is that term for the tampering of a witness? I can't remember what it's called. Yo, yo, subordination. Okay, gotcha. Thank you. Okay, it is subordination, subordination, SUBOR. Subordination of perjury. Subordination of perjury is the serious criminal act of persuading, inducing, or bribing another person to lie while under oath. It's a felony offense treated equally as severely as committing perjury yourself, carrying heavy penalties, including significant fines, prison time, and if the offender is an attorney, disbarment. So that is what that arrest was for, and that is something that occurred about almost 2 years back. There are various thoughts as to why. Thanks, John. As to why it took so long, and then it was like, well, why now? So that is also going to be coming up at some point. Hi, Lisa. The amount may be what is determined in September, or court date is for financial obligation compliance determination, or their negotiation for the amount known. Apparently, there's an amount set already. And yeah, you're right. It could be any of those. But consulting with a couple of attorneys who have been following this also for years, it was my opinion, and they agree with me. Yeah, I'm not an attorney or anything, but it was my opinion that a dollar amount was set, and they put this out. They gave her 6 months. That's when the status hearing was, from March to September, is to come up with whatever that monetary figure is. And because it was so far away, 6 months, I think it's got to be that she's got to pay back money. That's why they put such a long, so much space in between now and then. That's what I'm thinking. That's what I'm thinking. Would they garnish it? Actually, no. If she, if there's a deal made for a certain amount of money and it doesn't get paid back, they could just, you know what? Deal's off the table. You are remanded, and it's 5 to 8 to 10 years or whatever time that they give her, and she would be going away. I suppose. I mean, the judge can do anything. He could say, "Well, we'll give you another 3 months if she walks in and she's got X amount of dollars." I suppose the judge can say, "Well, you're close, but you know what? Let's do another 3 months, and then that's it." Deals happen, and that can happen. I hope it wouldn't happen, because this thing is going. It's pretty soon. It's going to be 10 years that this case is out there. 10 freaking years. Hey, see, friend. Yeah, restitution is usually the fraud dollar amount in court costs. Usually is. unless they make a deal. If they make a deal, it could be. I've seen court costs that are due to an attorney. Oh yeah, they owe $10,000. All right, well you have to pay back $1,000. By end of December, and the attorney's he's stuck. It sucks because he only gets part of his money. So I've seen that happen, and at this point, anything is possible. Yeah, 9 September 14th. That's the number in play. Can we can we go to the courthouse and protest till they are tired? Hey, you can do whatever you want. Need some banners made or something, or some signs. We'll try to get you on, Fox News, CNN, MSDNC, CBS, NBC, ABC, ESPN. We'll try to get you all over the place. Which she says maybe she's selling her house and moving to pay it back. Then she says, good point. I'm glad you brought that up. She did say that a couple lives ago. Or was it the last one? I forget because I've been showing some old videos. But she made it sound like she's leaving. And it sounds like she put the seed out there that she's leaving. So when she leaves, it's like nobody's like surprised. Like possibly putting that seed there. So if something happened, have to sell the house or it's foreclosed on or something, that seed is planted. Well, yeah, well, I'm gonna move. I'm gonna move. To cover what's really happening, to save face, and people do that. And I don't blame her. People do that. People do that. Yeah, we tune in. Once the book is released, it will be a tell-all book. Or will it? Or will it? It's almost like a unauthorized unauthorized autobiography. You know, because whatever she writes in there, it's like, and I don't think she cares, but it's like, who's gonna believe it? Those that know, and they know she's full of crap. But those that don't know are the ones that are like, oh wow, she was treated horribly. What a poor girl. Those are the ones that don't know. And that's what she counts on. That's what she relies on. When that book comes out, we'll do a book reading. We'll do giveaways. And maybe even a book burning or something, like. Oh, interesting. I hope you're right. I hope you're right. There's someone who has worked for the state and conducted some of these uh, uh, fraud cases and fraud hearings, and they're kind of telling me like it is. And I'm like, I hope you're right. I think it's not right that people get away with this stuff. And to be honest, I mean, if you live in the state of Texas, this is our money. She stole our money. The money that they get comes from the taxes that we pay. So ultimately, once you trickle it down, we are the victims, the regular people who work every day. And Shahan says, cover story for prison. Sounds like someone is losing their house to the bank. No wonder she got pissed when the news broke 2 months ago. Oh, I don't know about that. I don't know if any of that's going on. But she did say she was moving. She's moving. Well, if she's moving, she's got to be moving with someone, or someone's helping her. Because she has always said she will never move somewhere where she doesn't know anybody. She didn't even want to go work in a different city, like in a big city. She didn't even want to go take an assignment there because she didn't know anybody. That's what she said. So, to be continued, if you're keeping track of all this, September 14th is one significant date, unless something happens before that. I'll get an update tomorrow, see if what the dockets are updated with anything. The docket is updated with anything. And you update you guys on that one. And I'll show the other document. These are other court documents. There's a lot of information on there. We'll do that tomorrow. That one, I got to go on earlier for that because there's a lot of stuff to go through. Again, it is public information. It's not anything I've obtained in a shady way at all. Um, Texas Rangers and the state attorney's office is making sure that she's not getting away with a 13-year-old. I'm just curious what the rest of that deal is, this agreement that you saw. I wonder what the rest of that is. It's like, ooh, to be a fly on the wall to know those details, right? Hey, Cheryl. How you doing, Cheryl? So, we'll leave it there with that update. That's just something that it's probably been out for a while publicly, but someone found that little gem and I was like, yeah, very interesting read, definitely. Again, if you want to see that document, the determination from the Court of Appeals, it's on my page on Facebook, Manny's Hard Truth, and it's pinned to the top as a what do you call it, a feature or yeah, featured. So feel free to check that out and give it a good read. That's all I got for you tonight. We will continue tomorrow. I have the other stuff, a lot of other stuff to look through. And we'll check out. Well, let's see. Hey, Vicky. She's saying it because she knows she's going away to prison. Yeah, I don't know if it's prison. I mean, if she pays that money back, it sounds like there would be little to no prison. Hey, Nicole and Chris. It sounds like there would be. I mean, if it's a deal, there would be little to no prison time. At least that's, again, just an educated guess. But if she doesn't know, if she doesn't, that's what I'm interested in. Whatever that dollar amount is, if she does not come up with it, then what happens? And I can do, it's like now it's appropriate to do okay, September 14th comes, she does not have the money, whatever the restitution is. Then what happens? Yes, inquiring minds want to know. And she's going to say, it's nobody's business. And again, I'll say, you made it everybody's business. By inviting people to your life and by claiming to be a victim and claiming, all the stuff that you claim, everybody's hella interested. I would say that's what they're interested more than anything else is, how is that going to end up? What's going to happen? Thank you, Perfume Lady. What is this? Yeah, I wish I could play that. I like it. I like that as a background music. It's like casual, like a lounge kind of thing, but they don't let you. So Vicky thinks it's prison time. I mean, why would you, it just sounds, what is that? What's the word for that? It's like you're setting up your viewers or your followers that you might be possibly gone for a little while. I mean, we know. And that is the whole story. Is that what he said, right? Was that what it was? I want to say it right. No, that's not what he said. There's more to it. And that is the rest of the story, or something like that, right? Let's see. Yeah, that is the rest of the story. But then but wait, there's more. Because something more always pops up. It's like, this isn't gonna, something tells me this is not gonna end on September 14th. Something is gonna happen. One way or another, this may not end on September 14th. And the saga will continue. Thank you so much, Nicole. Yeah, feel free. It's not mandatory. Feel free to tip the jar, Cash App or PayPal or Venmo. Manny's Hard Truth. I appreciate it. Thank you if you do. If you don't, that's okay too. Follow me on Facebook, Manny's Hard Truth, and YouTube. Subscribe at Manny's Hard Truth. And be sure you hit that little bell and set the notifications, because some people are not getting notified. I know that's a pain in the butt, because I watch some other YouTube channels and I don't always get notified. I had to go back in there, toggle that little bell on and off, and then it gives you the little options. Same thing with Facebook, but it doesn't have a little bell. It just got those 3 dots and it'll say notifications. So I appreciate you all. Thank you so much. Have a great night, and we will talk to you tomorrow night, unless something else comes up. And thank you so much. Cubs win. Yes. Today was a good day. Yeah. Thank you, everyone. Have a good night.